Michael Bekesha is on with us, Judicial Watch senior attorney. Hello, Michael. How are you?
I'm good. Thanks for having me.
Good. So let's talk about Trump's case. Alan Dershowitz is coming on in a minute, and he's saying that he thinks he's in trouble on this one. You're saying the opposite. So explain the case that they have against Donald Trump and where you think the bright spots are.
Yeah, so basically the prosecution of Donald Trump with respect to the documents all started because the National Archives, somebody at the National Archives thought that maybe President Trump had some records that maybe he shouldn't have taken with him when he left office. That's how this started. And in the Wall Street Journal, I wrote a piece talking about a similar case that Judicial Watch had against the archives when it came to President Clinton and his records. While he was in office, President Clinton created these audio recordings. And on these audio recordings had all sorts of information. You know, they had conversations with foreign leaders. It had discussions about cruise missile attacks to get Osama bin Laden. It had information that would be classified had it gone through proper channels. But instead, President Clinton kept these tapes in his sock drawer and decided to take them with him when he left office.
And did he declassify them before he took them?
He didn't do anything.
Okay.
According to what we know, he simply took them with him. And Judicial Watch wanted the tapes when we found out about them. We figured, you know, these are presidential records. These are tapes showing President Clinton being president. So we sued the National Archives for the tapes. And in that case, between 2010 and 2012, the Justice Department, the Obama Justice Department, took the position that whatever President Clinton took with him were not presidential records, they were personal records, and there's nothing that they could do to get them back. In 2012, the district court here in D.C. agreed with the government, and the judge in that case, and she said, it is the sole responsibility of the president to decide what records are personal, what records are presidential, and once they are taken out of the White House, there's nothing that the court could do to get them back.
Now, is that because, I'm just trying to play devil's advocate, is that because these were tapes that he made and not top secret documents? Even though they may have contained top secret information, but he made the tapes.
You know, Glenn, it doesn't really make a difference because it wasn't as though President Clinton was, you know, pressing record and going out and buying the tapes. You know, based on, he was doing this along with a historian, and based on the historian's discussions about it, what he's told the public, the White House operations staff helped schedule the interviews, helped prepare the tapes, probably went out and purchased the tapes. And so the only thing that President Clinton did was place the tapes at the end of the session into his sock drawer. And that's very similar to what President documents.
Right.
If you look at the indictment, paragraph 2 says, while he was president, Trump placed documents in boxes. Paragraph 4 says, when President Trump left office, he took those boxes with him. To me, it's not a sock drawer, but it was boxes. It was the same process. President Trump decided what he wanted to keep, what he wanted to leave, and he took what he wanted to keep with him when he left office. Okay.
So help me out on this. Again, I want to ask you tough questions because I really don't know legally where this is headed, and except all the way around trouble. Trump's defense is that his actions were protected under the Presidential Records Act, but that act excludes, and I'm quoting, any documentary materials that are official records of an agency. So the indictment alleges that he had the information about our nuclear program, defense, weapons capabilities, potential vulnerabilities of the U.S. and our allies. Is it is it your view that these kinds of documents are protected under the PRA because of the Bill Clinton, or is there more?
There's more. The fact that the Presidential Records Act talks about agency records is really a red herring, because as the courts, the D.C. appellate court here found that really the focus is, are the records received by the president? Once the president receives a record from the agency, it's no longer just an agency record. It's now a record received by the president. So it has a different status. I mean, just imagine, it doesn't make sense that once the president gets a record from the agency, is it like a library book and he has to return it within 21 days? Absolutely not. It's his record, and under the law, he can do what he wants with it.
Right, and there are exceptions. No. It is treated that way with things like the nuclear code. He has access to that, but it's in a football held by a member of the Department of Defense that's with him all the time. So there are some records that do have to be signed in and signed out, right?
Well, maybe. I mean, the question is, what is allowed by the Constitution? And these are questions that really have never been addressed. The President of the United States is commander-in-chief. Everything in the executive branch flows from him. So there is one question on, what limitations can Congress place on the commander-in-chief, but also there's a question of whether or not Congress can mandate and require another branch of government to do something. And so there are strong arguments that if the Presidential Records Act is what some folks say it is, then that would be unconstitutional because it's placing burdens on the office of the president that's not allowed. The other question under the Espionage Act is authorization. While someone is in office, while President Trump was in office, he was authorized to maintain that information, to maintain those documents. If you went into the Oval Office, he could show you that document because he had absolute authorization to do what he wanted with it. So the question is, did he authorize himself to take those records with him when he left?
But hang on just a second, because he does have the ability to declassify, but even according to his own words in the indictment, there's a transcript of a conversation where he holds up a classified document to somebody and he says, somebody writing a book about him, see, as president, I could have declassified this. Well, now I can't, but so this is still a secret. So he knew that he possessed something secret. He knew that he hadn't chosen to declassify it as president. And now he's showing it to a member of the press, not as president.
Right. And the question there, and I think it's facts that, again, indictments are just one side of every fact. And
okay.
I don't know the facts. You don't know the facts. The American public don't know the facts. But the question is, whatever document he had in his hand, how did he get into his hand? And I think what we need to do, and what the public needs to wait, is to wait until all the facts come out to see whether or not he was in fact authorized to still have that record. And maybe the facts will show that he wasn't. I keep thinking, if President Trump, after he had left office, somehow got access to records he didn't have access to when he was president, that would be
a problem,
where a problem may lie.
Right.
But if the records were in his possession while he was office and he took an affirmative steps to maintain those records when he left, there are real constitutional legal questions about whether or not that was authorized.
Okay, let me give you a statement from Bill Barr. And I'm sorry, I'm just playing devil's advocate because I want to hit both sides. I'm going to hit Alan with the same thing. Both sides hard because I want to see, I want to ask the questions that people are not asking, but I think the American people are asking. There's a statement from one of not my favorite people in the world, former Attorney General Bill Barr. I want to give you a chance to respond to it. He said, quote, I think the counts under the Espionage Act that he willfully retained those documents are solid counts. They gave him every opportunity to return those documents. They acted with restraint. They acted very deferential to him, and they were very patient. They talked to him for almost a year to try to get those documents, and he jerked them around. They finally went to a subpoena, and what did he do? According to the government, he lied and obstructed that subpoena. And when they did a search, they found a lot more documents. They're official records. They're not his personal records. Battle plans for an attack on another country. Defense Department documents about our capabilities. In no universe, Donald J. Trump's do these belong or are personal documents of Donald J. Trump?
There's a lot there. To begin with the end part, the Obama Justice Department would disagree. So with the federal court that concluded that once a president leaves office, it is assumed that the president chose to take those records, had designated them as personal, and that there was nothing that could be done about it. And so just because former Attorney General Barr doesn't think those records should have been taken doesn't mean that lawfully they couldn't have been taken. The other interesting part is Attorney General Barr seems to focus a lot on the fact that President Trump may have not all the records that he had been asked to turn over. Well, under the Espionage Act, that's irrelevant. So even if he had returned those records, if the espionage is what everybody thinks it is, then President Trump could have still been charged under the Espionage Act.
Okay.
And so this idea that it's somehow different because he still had the records really is just showing an emphasis that he's displeased or unhappy with President Trump's actions and has nothing to do with what the law actually is.